need to open it. It is open. Okay,
It's recording.
to see right now if any of our attendees want to make public comment. If you do, please raise your hand. Oh, I don't see any. Okay. All right, Amos, you're overwhelmed by staff here. I thought this would be a good time just to kind of recap, figure out where we want to go. And maybe we can deal with the meeting on the 13th also. We've had some email exchange about that.
Great.
So I had sent around just my notes from the discussion. I think I sent them twice maybe. And then Professor Moore's comments on the draft rules with Greg's responses. I don't know, Amos, where you want to start, or Greg.
Yeah, I mean, I think we still have a lot of work to do working through the rules in advance of what we're presenting to the full working group on June, what's that date? June 10th, is that right? Or June 25th?
June 25th,
so, yeah. June 25th. So, you know, probably I defer to Greg if there's a order of preference on how we go through that with all the outstanding issues and all the comments we received from the full working group. I do have a number of notes on things left for the regulation subcommittee to do. So I don't know if you want to go through sort of the high level of to-do items, but I think, you know, the main one is going through the draft rules and seeing where we can finalize them.
Okay. Yeah, we do have another to-do related to proactive regulation that we'll have to dedicate some time to. I guess it seemed to me that there are sort of a big issue around the disclosures, around informed consent. You know, what exactly is this going to contain? So I guess in my mind, I was thinking maybe we could start there, but Greg, I think it's a good ask.
I agree. I think we could discuss that particular rule and requirement, and it's great that Andrew and Randy are here too, because it provides some deeper expertise probably than I can provide. But I also think we need to, and we may need Fariba to really finalize this, obviously. But Steve Flashman had some interesting points to bring up, speaking against allowing fee sharing and allowing paraprofessional ownership in firms, and those are critically important issues that we need to decide that affects many different roles. I think we could discuss that now, but again, I think we need Fariba to come to any sort of decision on this. My understanding of Steve Flashman's position, he feels like there's a very easy solve here, which is paraprofessionals can combine into their own firms and own their own firms. But if they choose to practice within a firm, including lawyers, that they cannot have any ownership stake. And they should be treated like employees or contractors. I suppose they could be contractors as well, but not sharing legal fees, and certainly not sharing legal fees for work that they would never be licensed to do on their own. And I think his position is once you make that decision, it makes drafting these rules a lot easier. So
I think that's exactly right. And those are both things high on my list. It's referral fees too, I would say. So there are referral fees and ownership rules if paraprofessionals and lawyers combine. I think we need to talk through that. I don't know how difficult it would be to really set it up as sort of two options for the full working group, because there are so many rules that are affected. You know, we probably are better off making a decision and going with one. But I think this is an unresolved and controversial issue that, you know, it might be worth seeing if we could do two tracks and sort of say, choose both for the full working group and maybe the state bar and the court, because, you know, it's sort of a critical issue. That's right. And I think I would include the referral fees in there too,
Yeah,
because I
absolutely.
think they're related rules, but different rules. And so, yeah, I'm fine starting with either of those. Those I think are two of the main issues we need to do. I also went through the rules. So there, there's other things we can talk about. So I defer, Greg, to you if you want to start with one or the other.
Well, I really don't have a preference. I guess we could start by talking about referral fees, and fee sharing, I guess, is really the more appropriate topic, the way to frame it. One thing that Steve and I had an exchange, I think, in the last meeting where he tried to indicate that he had a different position than I did, but actually, from what he said, I don't think we really did have a different position. I had indicated that California is not the only state that allows pure referral fees, but that none of the states that currently have a paraprofessional program similar to the one we're contemplating allow that type of pure referral fees among attorneys. And he brought up that, and this is the ABA model rule, and I'm going to let Andrew and Randy correct me if I'm wrong, but one of the reasons referral fees are allowed under our rule structure is that when we allow fee sharing among lawyers from different firms, the lawyer, at least one lawyer who's receiving the fee they're not responsible for taking on some proportion of the work attributable to the fee or a responsibility for the matter. And that's in the model rule, and most jurisdictions do have that in their version of rule 1.5.1. We do not have that. And that opens the door for forwarding fees, forwarding a matter where a lawyer can receive a fee back for forwarding a matter that's beyond perhaps their scope of competency, and receive a fee back, but they don't have to be on the hook for making sure that they're providing the same proportion of legal services proportional to the fee that they're receiving, or taking responsibility for the matter. Do I have that right, Andrew and Randy?
Yeah. The ABA model rule will say you can share fees with lawyers not in your firm if is either in proportion to the work you're doing, or, I think it's an or, Randy can correct me, you assume responsibility for the matter. So you have to have some skin in the game, as it were. In California, based on Supreme Court case law, there's a policy where they think clients are better served for a lawyer to be incentivized to refer that case to someone who's competent and can handle the matter, and receive a referral fee only if they go through all the disclosures required in Rule 1.5.1, which requires the client to consent to that referral fee, because they feel the client will be served by having competent representation. It actually benefits the client to do that. So that's the different policy approaches taken under the two rules, as I understand it.
Right. And so what could be an option here is to permit paraprofessionals to share legal fees as long as they're willing to meet that requirement, either provide a proportion of legal services that they obviously would have to be licensed and authorized to provide, that's commensurate with the fee that they're receiving, or take joint responsibility for the matter, which means they need to make sure they're providing competent legal services, or they have a duty to communicate, all the duties that are inherent in a representation of a client. That's something that we don't impose on lawyers, but it would allow paraprofessionals to share fees, and they wouldn't be pure referral fees. They would be fees that would be earned. And then, so that's paraprofessionals in different firms who don't actually practice together normally. The question is whether or not you want to allow them to share fees with lawyers, and that really just is a fundamental policy question. I think Andrew did a very good job of summarizing why we allow it among lawyers. The concern, I think, for the courts in California is that if you don't allow pure referral fees, you may have a lawyer taking on matters that they just lack competency to provide services for the client. And so it encourages them to forward that matter to somebody who is better positioned to provide competent legal services. That may or may not be an issue here. If, for instance, if a paraprofessional is representing a client in a family law matter and they're providing services within the scope of their license, and they discover that the person needs additional legal services that is beyond their licensure, they can refer them to a lawyer and not necessarily receive a referral fee, but they could have a reciprocal agreement with that lawyer so that the lawyer is referring, because that's permitted under 5.4 as it's written now, a reciprocal agreement where they're deciding, as long as it's not exclusive, we are going to refer matters back and forth to each other and not receive compensation for it, but at least have that network of lawyers that they can send their clients to if, for instance, they need somebody to help them with, with something that's just beyond the scope.
Can I ask,
go ahead, Ames. Yeah.
Can I ask how separate these issues are? So referral fees for paraprofessionals who are in different firms than other paraprofessionals or lawyers, and a referral fee versus fee sharing, and the ability to combine in a single firm. Do we need to be dealing with those together and have the same answer, or because they are interrelated conceptually and in the rules, or can we have different answers? Because I think at least some of the objections or concerns that are raised for sharing in the same firm, combining in the same firm and having ownership of the same firm, and delving into modifications to Rule 5.4 might be separate, at least somewhat separate from the referral fees, whether it's a true referral fee or there's skin in the game, at least as we talk through it.
I'll just offer an observation. I mean, this will be, I'm a staff person, so I'm hesitant to do it because it's kind of a policy recommendation. I also am curious on Randy's thoughts about this, but you could separate these issues and just start the conversation by saying, as we get the program off the ground, we're not going to permit licensed paraprofessionals to participate in a referral fee to lawyers. And a reason for that position might be there are other limited licensed legal professionals, LDAs, UDAs, paralegals, whomever, that can't engage in that type of fee sharing. And we're just trying to get the program off the ground. Licensed paraprofessionals should be encouraged when their representation is limited based on their licensure to tell the clients, you need to speak to a lawyer. They should be encouraged to say, here are some certified lawyer referral programs, or here's a lawyer I know, or here's a law firm I know that handles this area. Please feel free to contact them, but not engage in a referral fee for providing that information. You could look at that issue separate. And then once you reach a conclusion there, transition to whether paraprofessionals should be able to engage in referral fees amongst each other, which I think raises different and more limiting policy concerns in my mind. And then you got to get to the other issue, which I see where Amos is going, that this is all intertwined. The other issue of sharing legal fees with lawyers in a law firm in which the paraprofessional is also working. So there could be three different layers, but that's just how my mind approaches it. That's not to say it's the only way to do it.
So in other words, you think it can be separated into those three separate buckets, and we could have different answers for each. So in other words, referral fees are allowed between certain people, no fee share. You can't have ownership in a law firm and share fees, or vice versa. You could do, yes, referral fees are allowed. No, referral fees aren't allowed, but you can combine in a firm and share fees that way.
Yeah, I mean, you could certainly get a salary. That wouldn't be a problem. Could be, and
5.4 allows employees of firms to participate in profit sharing as well.
Exactly.
So, it gets very esoteric quickly, because at a certain point, it's like, what is fee sharing and what is profit sharing? I mean, all the profits are coming from fees anyway. So, but I think essentially, I agree with Andrew. You can approach it from that direction, and I think the more simple approach is probably advisable here, because we are standing up a new program, and I do think it does get a little tricky if you buy into the notion that a paraprofessional should not, working in the same firm with lawyers, should not be permitted to share fees that are generated from matters that they couldn't provide legal services in. Then it gets very complicated. But they can share fees that are generated from matters where they're providing services. Just from an accounting standpoint, I think it would give their controllers a headache trying to map all those different fees and what their paraprofessional owners of the firm can what percentage they can receive, what can't they receive fees from. So it becomes a very complicated, I think, to try to trace that. I do wonder what exactly we're trying to guard against from a policy standpoint, because I think Steve Fleshman provided the example. What if we have, and I think Leah reflects this in her notes, what if we have lawyers who are, some are doing trust and estate work, some are doing family law work. We have a paraprofessional who's also doing family law work. And because they're all co-owners of the firm, some of those trust and estate legal fees are going to find their way flowing towards these paraprofessionals. And that's concerning to some people, including Steve Fleshman. But I wonder what we're trying to guard against, because 5.4 is really focused on preserving the independent professional judgment of lawyers. And if we think allowing that kind of fee sharing is going to affect the professional judgment of the lawyers in the firm, I'd like to hear the rationale for that, especially since we've already decided they are not going to have over a 50% ownership in the firm. So they're not technically going to be able to control the professional judgment of the lawyer. They also can't supervise the lawyers in the firm. So in some ways, the way the rule is written now, it is focused on preserving that independent professional judgment. So I'm not quite sure what the rationale is, but I do understand that it gets very complicated very quickly if you're going to try to create a wall around certain fees within a firm that paraprofessionals can share in, and then other fees that they can't share in.
So this was one of my biggest takeaways from that joint meeting, as the concern that was raised, and it seemed to be shared by many others. Again, without maybe that explanation you just gave, and some more background, but it seemed like there was a number of working group members that had a concern about fee sharing beyond the licensed practice area. And I think that directly implicates the ownership issue, because I don't think we should be, if we are allowing paraprofessionals to have ownership interest in firms that have attorneys, I don't think we should be trying to do this kind of splitting. I mean, that's not what ownership is. Ownership is, you own X% of the stake, and, you figure out what all the expenses are, and there are profits. And it might be a very good business model to have, family law, 10 paraprofessionals working together. And then, they expand their practice to include a couple lawyers to do other things that, and they can tell. And so there's a lot of different business models. And we don't want to be getting into the details of, which ones are allowed, which ones aren't, how do you split those fees, what's the accounting? I think that would be a mistake. I happen to believe what I think follows from what you just said, Greg, which is, I think allowing ownership of a minority stake in a firm with both is a good idea, and allows paraprofessionals a path to greater income and good business models. And I don't know what we're really afraid of by prohibiting it. But I don't, if there's a real concern that paraprofessionals should not be getting fees directly or indirectly from unlicensed practice areas, and I think we have to really go back to square one, which is we might not be ready to allow ownership in joint firms. I think that's the better decision than trying to hair split of allowing ownership but not allowing sharing of fees, which I don't think works.
Yeah, it becomes very difficult. And I mean, reflecting back on the conversation, I started my career in a large law firm doing labor and employment work. We were not the big movers in the firm. We were really a value add for the people that were doing antitrust work who needed to have some employment lawyers that they could refer their big clients to whenever they had a need for it. And certainly the partners in the firm that were doing labor and employment, even though they were licensed to, they're omnicompetent, as Professor Sandifer likes to say, they could have done antitrust work, but they had never done any in their entire life. And yet they were still sharing in those antitrust legal fees because they were just equity partners. And that's the way it works. So that's a fundamental policy question. I think you and Fariba probably need to come to, again, some consensus on how you want to approach that. And it's going to then inform how we draft the rules from that point forward.
Right. And just again, on that business model is a good example, because the idea is it's cyclical. It is a business as well as a profession. And sometimes, the bankruptcy practice is busy, sometimes litigation's busy, sometimes corporate busy. And it's a good business model to have a diversification. Again, I don't know that we should be getting into, we're trying to draft ethical rules. And I think our focus should be on independence of decision making. So I do think, there are some fundamental issues there, but I'm not sure allowing a minority interest really implicates that. But it does seem like we have some work to do on education about that if we want to try to push that through. Or again, we might come to the decision that maybe we're just not ready to do that. Fundamentally, though, this is why I really asked my question of, can these issues be separated? Because I think that discussion and fee sharing and ownership might lead to the conclusion maybe we're not ready to do that for ownership in a firm that has both paraprofessionals and lawyers. And by the way, that would also simplify a lot of the supervision issues in Rule 5. But I don't know that implicates referral fees at a different firm. And in fact, I think that might support why there should be referral fees, because if a paraprofessional and a lawyer can't join together in a combined firm where the paraprofessional has ownership, we might want to more incentivize that referral from a paraprofessional to a lawyer. So I actually think that I would do flip what I think Andrew, at least the hypothetical was, which is maybe we pause on the Rule 5.4 fee sharing and ownership, but maybe we still track the rules for attorneys. I don't think we go beyond that, but maybe we track the rules for attorneys on referral fees for paraprofessionals that are in separate firms, so to follow the policy that exists for attorneys and encouraging that. If there's a concern about abuse, maybe, I don't know if there's any kind of caps or limits for attorneys on those, but maybe we can consider some sort of cap or limit. But I would like to see us follow the attorney rules for referral fees.
And when you say follow the attorney rules, do you mean also allowing referral fees between paraprofessionals and lawyers in different firms?
Right. Yeah.
Okay.
So in other words, treating paraprofessionals as a licensed professional that can practice law. So I think that's the issue, or again, it's a semantic issue, but I think people who are raising objections, I think there's a policy question. Are paraprofessionals going to be treated like LDAs or like accountants, or are they going to be treated like other licensed professionals that can give legal advice, attorneys? I think all the policy reasons that we just talked about for why California doesn't follow the model rule apply to paraprofessionals. And again, maybe even more so with respect to wanting to encourage paraprofessionals not to extend beyond their competence or extend beyond their licensed area.
And I think that's a really good point, Amos. You may get the same objection that if you allow pure referral fees or forwarding fees between paraprofessionals and lawyers, that paraprofessionals will be receiving fees for services that they are not licensed to provide. But you know, again, my response to that, just because I'm always thinking towards the presentation to the court, and they're going to want to know what is the rationale for not following the rule that we have for lawyers. What are we trying to protect against if we were to allow that type of pure referral fee? And the other point I think that's important to make is Rule 1.5.1 is the safeguard. That is that they have to comply with that rule in order to share fees. And that means the terms need to be fair and reasonable, they need to be disclosed, and you need to obtain the client's informed consent before you enter into that arrangement or shortly thereafter. So
and it can't increase the total fee, right? Or is that a different?
And it does not increase the total fee. That's another safeguard that's in that rule.
So yeah, no, and this is complicated because I think it's controversial and there's really good points on both sides. But and we're line drawing here on policy. Again, I think even with ownership, I think, as you know, and as I've said during prior meetings, I would be in favor of allowing ownership of joint firms with paraprofessionals and lawyers in a minimum capacity. But I think maybe the best result is to move off of that, to simplify it, to not have to deal with so much of 5.4 at this point, have that for further study. But I don't know that changes my mind on trying to follow the attorney rules for referral fees and encourage paraprofessionals to refer when appropriate and when disclosed and with informed consent and with the protections of 1.5.1. Again, that still remains controversial, I think. So we'll have to really work through that and maybe tee it up for the full working group to have, choice. Again, I know that is difficult because there's so many rules affected, but it might be that we need to have this, again, kind of full in front of the full working group.
Mm-hmm.
But I think that's where I land right now. I'm open to being, to discussing it further.
Yeah, and I think if Fariba lands in the same or similar spot as you, I didn't get a sense. I did hear opposition from Steve and I think a couple other people, but I didn't get a sense that there was a majority of the working group that didn't share your perspective on this. So if both you and Fariba tend to agree with the underlying policy decisions, then I would probably encourage you to move forward and put it to the working group. And we have the way this whole work plan is now mapped out, these rules are coming at the very end. They're the caboose of the process, because even after the legislature acts, we're still going to have to come back to these rules based on what exactly the legislature decides to do about this program and how they want to shape it and craft it as well. So I wouldn't worry too much that we need to have these rules solidified by June. I think it's helpful to have a set of rules that are comprehensive and well thought out, so that the working group can make a decision, and then from there we can adapt.
That's fair enough. And we also may receive public comments on this. It might also be helpful. I know, Greg, you've already done this analysis, but to look at what other states are doing in this area. I think it was across the board on the ownership. I'm not sure on the referral fees, but I know on the ownership, some didn't allow it and some allow it minority interest. But I'm not sure on the referral fee.
You're right on that. I think every state allows some form of firm ownership with the paraprofessionals and lawyers. I think triple LTs can own a stake, and I think Arizona it's wide open. I think they're the most liberal in this regard, but I don't think any of those, Utah, Arizona, or Washington, allow pure referral fees for lawyers either. Right. So I don't think they would allow for.
And I did go back on Rule 5 on the ownership issue, and I was also getting stuck, quite frankly, on the supervisor role. So if you have a paraprofessional that's a 25% owner in a firm, are they a supervisor to attorneys, and how that would play, and their independent judgment, are the attorney supervisors of them? And it does get somewhat complicated. Again, I don't know that we're solving these issues if we don't allow ownership, because we still have, I think, the possibility of paraprofessionals working in law firms. And I think they would still need to use their independent judgment as paraprofessionals. They're not the same as paralegals that are working under the direction of an attorney. So I think there's still some sticky issues there for us to work through, but I think it just gets complicated if they're owners and maybe significant owners.
Right. Well, we do have, I think currently in the version of 5.4 F2 states that a licensed paraprofessional will have no direct supervisory authority over any lawyer in the firm. So you have to probably read that in combination with the supervisory rules. So essentially, to the extent that they're a managerial or supervisory paraprofessional, it would really apply to their supervision of the non-lawyers in the firm that are under their direct control.
Can I ask a question? So with respect to fee sharing, is the only rule not fee sharing, referral fees, is the only rule at issue 1.5.1?
No. The rules that are implicated by fee sharing are 1.5.1, 5.4, and 7.2. Do I have that right, Randy and Andrew? Yeah. Okay.
7.2, compensation for referrals. 5.4, the professional independent, and the 1.5, the actual fee sharing. And let me just throw something out, because I think you said something, Greg, early on that was very, I think, persuasive in my mind, that since we're standing up a new program and these are complex issues, that there might be a great interest in keeping things as simple as possible. And that got me thinking that if you put aside the ownership issues, just set that aside completely for the moment if we can, think strictly about fee sharing. And fee sharing in California, referral fees is just a subset. And so the California Supreme Court in Chambers versus Case said our fee sharing rule applies to both joint co-counsel relationships between lawyers in different firms where you're sharing the handling of the case, as well as referral fees where there might be some sharing, and even pure referral fees where there's no sharing at all in terms of responsibility or division of labor. And so our fee sharing encompasses all of that. And that's where you get, Steve's problem about having some sort of stake in areas of law that you're not licensed to engage in. And so if you wanted to approach that as simply as possible, I think you could use the ABA rule. I know Kevin will probably be mad at me for saying so, but you could use the ABA model rule on fee sharing, use it as the standard for both fee sharing between paraprofessionals and lawyers, as well as the standard between paraprofessionals and different firms. And I think you cure a lot of ills by taking that approach, because the requirement of either shared responsibility or division of labor keeps them in their licensed practice area. They wouldn't be able to share anything. Now they could still, quote unquote, refer, but it would have to be, again, within that scope of limited expertise licensure. I can refer you a case because maybe, I do X and you do Y, but I can refer it to you because I have knowledge about that. I think our pure referral fee rule in Moran versus Harris, where it says that we want to give a financial incentive, relies a little bit on the fiction that at one point, every lawyer passed the bar and knew a little bit about every area of law.
Yes.
And if we give them a financial incentive, they can tap into that knowledge of the entire law and say, I know that this isn't workers' comp, this is something else, and it's third-party liability, whatever it is, I'm going to refer it out. And I have enough knowledge about the breadth of the law to at least refer it out safely and not make a negligent referral. And particularly if I have a self-interest, if it's a typical referral fee where you only get a portion of what the other lawyer gets if they ever collect, then you're going to refer it to someone who knows what they're doing. Right. I don't know if that rationale holds up for paraprofessionals who haven't been exposed to the entirety of the law. So why would you give them a financial incentive to try to figure out who it goes to if they really have no baseline knowledge for doing so? But if you keep them in check with the ABA model rule, I think that's kind of a simple approach. You use that for among paraprofessionals, you use that between lawyers and paraprofessionals. And I don't want to lose sight of the lawyer-paraprofessional fee-sharing relationship, because I always thought that these paraprofessional activities would be a way to allow law firms to engage in more legal services activities. They can do more modest means representations, because instead of using associates and lawyers, they could join together with paraprofessionals in those practice areas and share fees with them in order to offer more services, provide more access to modest means, because they're not having to use the high cost of their lawyers to provide it. They're banding together with paraprofessionals. But stick to the model rule, and I think you might be able to get there.
How does the model rule work in practicality? I'm struggling with, like, what does that mean? So, like, I'm a paraprofessional. Let's say it's within my practice area, family law. There's a bunch of authorized things. I can do it, but I don't really think I should do it. I think somebody else is probably better at it than me, either another paraprofessional or a lawyer. How does the model rule work? What does it mean to meet one of those prongs? Seems like
there are two options. You have to be in proportion to the work. So I'm going to do 50% of the work as the person I'm referring it to. So I'll get half the fee in that example. Or I'm going to assume joint responsibility for the representation, which means I better keep in touch with the person I'm referring it to, because if that person doesn't show up, fails to communicate, drops the ball with accounting for money, I'm going to be on the hook for discipline and potentially, this is outside the scope of the rules, but malpractice liability. Yeah. So, so the second prong, I agree with you. It's hard to gauge how much quote unquote participation that the referring lawyer is in, but by virtue of the agreement, and I'm not sure the ABA model rule speaks to the details of the written agreements as well as the California rule. But in terms of the agreement, it keeps, as Randy says, the referring lawyer in check, because they're going to be on the hook should something go wrong. It also says, I'm not going to refer this case to Joe Schmo down the street because he might drop the ball and then, I'm in big trouble. So there's a variety of protections that approach takes. Of course, we can debate and argue as to whether that they're better or not, but I think that's a very brief summary how the model rule works.
And the model rule does have the requirement that the client agrees to the arrangement, including the share that each lawyer will receive. And they have an agreement confirmed in writing standard. They don't have an informed consent, but they still also have that the total fee is reasonable. Now that's slightly different from, it's not increased by virtue of the division of fees, but it's interconnected with their regular fee arrangement rule 1.5 that is a reasonable standard for fees in general. So they have similar protections as our rule, but they have the long-standing requirement of division of labor, proportion amount, and joint responsibility, which I always felt the crux there is you're in an attorney-client relationship with that person. They didn't come in, see you, and you didn't decline to represent them and say, go see Susan or Charlie, and I'll get 10% of their 50%, whatever it is. You're saying, I'm going to represent you, but the lion's share of the work is going to be provided by somebody else, but you still have to sign an agreement with them. I mean, like Andrew said, you're going to be liable to them for malpractice and discipline for any duties that flow from that attorney-client relationship.
That's essentially what it means to continue responsibility, is that the representation continues. You are not withdrawing from representation. Whereas here you can. You can share in the fees, and as long as the client agrees to it, you're essentially withdrawing. That lawyer has no responsibility to continue to represent you as long as you agree to that fee share.
I don't know, to a lay person like myself, it seems like a pretty convoluted and inefficient, and sort of like, if we're like, why do we want people to refer? We want them to refer because they can't do the work, and we don't want them to do it themselves. So I'm not sure if these were the sort of imposed on me in order to refer. It's like a chilling, like, why do I want to do this? I don't know. To me, again, it just doesn't, I don't know that for what it's worth, I don't know that I think that's a great solution.
It does hold in check referrals. Our rule, California's rule, is much more encouraging referrals. The whole point of the ABA rule is to guard against what is they perceive as the dangers of pure referral fees. So that's absolutely how it works.
That is how it works. But again, I think there's a reason for that, right? So the idea is the concern about fee sharing and referral fees when you're not working on the matter is independent judgment, right? The big issue, and so I would say rule, what is that, 2.1, that you have to have independent judgment. The concern is if you're sharing fees with a corporation, a non-attorney, if you're getting referral fees and there might be other people that are responsible or who pays the fees, all this stuff, I think there's an underlying issue of independence and concern about messing with that. And so I think the ABA rule is just tailored different. It's not that it's discouraging referrals when somebody's not competent or doesn't do that practice area. It's just saying they should refer it and they shouldn't be able to share in the fee for that work that they are not competent to do and they don't practice in that area. When a non-attorney refers, that's different than when an attorney refers for the reasons Randy discussed. And so I see the point that, hey, we want to, these rules make it convoluted, but I think what it's protecting is the underlying issue of not sharing fees or paying for or making it a business to just do referrals when you don't have any skin in the game and you don't practice in that area. Again, I think the complicated thing about paraprofessionals is, let's take landlord-tenant. They're going to have limited, they're not going to be able to do trials as currently. So what about a paraprofessional who says, I can do everything up until trial, but if you're going to need to go to a jury trial, I'm going to refer you to an attorney. Are they going to be able to get a referral fee for that? And do we want them to be able to get a referral fee? I think if you apply the ABA model rule, you would not be able to do a referral fee there because that's not something they're able to do within their license, right?
If you couch it in the terms of referral, I think that's absolutely right. If you're looking at it in terms of, say, a law firm that's trying to provide more access through a modest means sector of their firm's work, then maybe it is, when the case comes in the door, the fee sharing is that the law firm knows that there's a paraprofessional firm that can do some of the work and will work together with them. And it's a single, really, representation from the client's perspective, but there's actual division of labor between what the law firm is doing and their strategic partners, this separate paraprofessional firm will do. And they are now jointly responsible. They are now only dividing fees in accordance with their division of labor. And the client is the winner in the end, because instead of having to pay attorney's fees for the whole case, part of the case is being done by a paraprofessional in their area of licensure, in concert with the lawyer taking on the activities, the representation in court that the paraprofessional couldn't do. And so I like the idea that the ABA rule works for when people are working together. I agree with Leah that our rule is better for referral purposes, but I do think, the whole history of California's referral fee sharing, started with something more restrictive like the model rule. And only when you know, we got into the specialization of lawyers as opposed to generalists, that the nature of and the need for referrals, the practice of referrals became more significant, and the rule changed with the appropriate client protections to allow for pure referral fees. This is a brand new program, so I don't know if you jump all the way to the same policy as the lawyer rule and say, you know, we need to have complete free referrals as long as the basic protections are there. I think you have a rationale for saying it's a new program. These are not exactly the same as lawyers. Can we start with what might be a tighter regulatory sort of approach? And if we see that there's no harm, that the relationships between paraprofessionals and lawyers and law firms in terms of fee sharing, including whatever limited referrals are going to happen under the ABA approach, once there's a track record for that, then the court, the same way they did in Moran, can say, maybe we can open it up. Let's make it wide open. I think that's one way that I like to think about it, that just because you start with the ABA rule doesn't mean you end there.
Elizabeth Alvarez, who's on our working group, had her hand up for a while in the guest. So Elizabeth, can you go ahead?
Hi, thank you for the opportunity. I just wanted to give you guys my name is Elizabeth Olvera, representative of California Association of Legal Document Assistants. I just wanted to give a perspective of the legal document assistants and what they're doing now, since they've been working with the public directly, and they've come across this issue multiple times, sometimes on a daily basis. My experience has been that LDAs pass on these referrals without receiving anything in return in terms of compensation. The LDAs give away the whole case when they feel that they are not the best person to do this type of work. They give out the referrals to bar associations, nonprofits, and other LDA offices. And the reason they do that is because there's many benefits to that. Number one is the client is served, whether it's the LDA doing the work themselves or not. It gives a ray of hope to the in pro per that they are going to be met their legal services. The other thing is the client is now served by someone who's competent. And many times I've had to tell people, I would be doing you a disservice if I tried to take on this case when they're sitting there and begging for my assistance. And you know, I feel confident in my referral list, and they're in good hands. I say you're going to be in good hands. Another reason is the LDA has a hopes that the referral partner will eventually send work their way, right? An example, I'm based in San Francisco. I speak Spanish. And so I refer constantly to a LDA in San Mateo because she could do the same work that I can, but she's in another county. And then that LDA will refer work to me when she gets a Spanish speaking customer. And so it's a, you know, give, and it works. Mm-hmm. That's the only comments I had to make. Thank you.
Thank you.
Thanks, Elizabeth. Yeah, I would say to Randy's point that in thinking forward to a rationale for adopting the model rule approach here, I think you put it well, Randy, that at least a sound rationale, I mean, I'm sure some other people will take a different position, but is that this is a limited license, and really the purpose of allowing pure referral fees for lawyers is that they have the option of trying to become competent enough to handle matters that they're not currently competent to handle. And we're probably going to see a different situation with these paraprofessionals where they may encounter legal issues that they simply are not authorized to do. And I think Elizabeth's comment sort of points this out as well, in that she refers out clients where she is probably not able to provide them the services that they're looking for, and she's happy to do it. And I think it's, you know, she's in some, sorry, that's my dog, in some reciprocal relationships with probably organizations and others who are referring work to her. Let me let my dog out. Sorry about that. taking care of my in-laws' dog while they're having my mother-in-law's having surgery today. So in terms of having a rationale for doing something differently, I think that there is a rationale there. And I think Randy did a pretty good job of explaining that. Not that I'm advocating for that position, I'm just saying that that does exist here.
Does it assume that the primary reason that a paraprofessional would be referring a case out is because it's not within the authorized scope of their license, rather than I can do it, but I'm not that good at this particular thing, or I don't want to do this particular thing, even though I'm authorized to do it?
Well, if you follow the model rule approach and say, for instance, you have a family law paraprofessional who is authorized to do a number of activities that we've already identified, but they really want to specialize in, spousal support, for instance, and they don't really want to deal with child support issues, and they want to refer. Under the model rule, they can share the fee as long as they're willing to take joint responsibility for the matter, right? So, and it's disclosed to the client, and they meet all the other requirements of the rule. So they can share a fee, but it's not considered a pure referral fee where they're simply withdrawing from the matter entirely. They wouldn't, if they were referring out something that they are just not authorized to do, then they wouldn't be sharing the fee, because they can't, do a proportion of the work, and they can't take responsibility for a matter that they can't provide services for. So,
and we're sorry, I got a little lost. We're still talking about simply fee sharing or referral fees. I agree with Randy. It's really important that that they're two different concepts, although they're combined in the same rule. We're speaking to that between licensed paraprofessionals. We're not talking at this time between a licensed paraprofessional and an attorney. Is that correct?
No, I thought we were talking about both.
I thought for simplicity, you could do both, but I think for analytical purposes, you might start first with paraprofessionals, throw that up against the wall, see if it sticks, what are some of the issues with it. And then if you do the same thing with the paraprofessional to lawyer, and you reach the same sort of conclusion that this might be a simple or safe way to go to start this program and keeps paraprofessionals in their lane. And then you just see if, the other thing, I almost hesitate to say it, is that when you're talking about this particular program, I also start to wonder what is politically possible. And I do think pure referral fees is a tough sell. And so the model rule, which does not resonate the same as pure referral fees, might even be appealing because it has a rationale and might be more politically possible.
So the reason why I was asking just really quickly is because I think it would limit and possibly eliminate the ability for a licensed paraprofessional to engage in a referral fee with a lawyer, because they can't do a portion of the work if it's a situation in which Lee identifies it's outside their scope of authority. And how do you assume joint responsibility for a matter in which you can't be responsible? So to Greg's point, I can only do a handful of family law cases. This client also needs criminal law representation. I'm going to refer him out to a lawyer.
I think
so you could still refer them out to the lawyer. You just couldn't get paid.
Exactly.
7.2.
Just want to make sure we recognize that.
Greg mentioned earlier allows for reciprocal referrals that are non-exclusive. Mm-hmm. And again, I'm thinking about the good things as opposed to the risks of the evil actors out there. And I'm thinking about law firms who want to do more modest means work, and that there are paraprofessionals in the particular areas of law, and they could absolutely have referral arrangements with that law firm for things outside of their licensure. They just wouldn't be getting a cut of the fee that the lawyer gets in the end.
But I think the way it would work, say it's within the authorized scope. It's Amos's example earlier on UD. I think it works in kind of a perverse way, because if the firm takes the UD case, right, in its entirety, the firm can then get a referral fee with a paraprofessional under the model rule, because the paraprofessional could do everything up to trial. So the paraprofessional could do 40% of the work, or 60% of the work, or 70% of the work. It's within the authorized scope of the attorney to take the whole case. But they know the paraprofessional is going to do everything but trial. So it's almost like the attorney is getting the referral fee from the paraprofessional, because the paraprofessional cannot take the whole case, but the attorney can, and then can refer a portion of it out to the paraprofessional and have this joint, this proportionate representation. That's how you could do it within these areas where there's a limited authorized scope for the paraprofessional, but the attorney can take the whole case. And I don't think that's what we're trying to set up, but that's how I think this would happen.
And if it did happen, I would hope the law firm would pass on the savings to those clients, costing less to use a paraprofessional to do that percentage of the total case.
Yeah.
Well, I'll just say at the beginning, I thought it was a separate. I retract my earlier statement that maybe you could separate these things between referring to lawyers and referring to licensed paraprofessionals. I did have a concern because I think it raises policy and, yes, even political concerns. But I think this conversation, for me, and Randy's approach with looking at the ABA model rule, solves a lot of the concerns I raised at the beginning of the conversation, and is in harmony with that, because you don't have this difficulty of the issue of referring cases to lawyers under the California rule between a licensed paraprofessional and lawyers, as that issue that I have in my mind is solved with the model rule approach, because it requires that the paraprofessional either work a proportional matter or be jointly responsible, and it's cabined into what the paraprofessional can do. And so if Fariba and Amos, I agree, it's their call, they need to look at it a little bit further, agree, I think, and to Greg's point, we'd have to come up with thoughtful, articulate policy reasons, but the model rule approach seems to address some of the current concerns I had in my mind when the conversation started. Conversely, if you go the California rule, then it does seem like different layers of, and they do seem like separate issues to me. You're talking about sharing fees amongst licensed paraprofessionals, which is different, and again, in my mind, from referral fees to lawyers as permitted under the California rule. So that was also inarticulate, but just to say, I think the ABA model rule discussion has helped, at least in my mind. I think my concerns are addressed there.
So can I ask a question? Because this is complicated. We might need to map this out, but I think there's really three options for the two buckets, right? For referral fees from paraprofessional to paraprofessional, and for referral fees from paraprofessional to attorney, or vice versa, attorney to paraprofessional, right? Because, we started, I guess, talking about the California rule, which allows for pure referral fees. Now we're talking about the ABA rule, which doesn't allow for pure referral fees and has these restrictions. And of course, the other alternative is to not allow referral fees, and that would more track what we have currently for non-attorneys who refer cases. And I think we're deciding between those three options in the 2 or 3 buckets. And, we'll have to rationalize or justify between the 3, not just between the 2. And again, I think my view of why I am really open to allowing referral fees is in what gets excluded if we follow the ABA model rule, which is encouraging paraprofessionals to refer cases that are beyond their competency or outside of their license. And I guess it's not the beyond competency if it's in the license, it's beyond their license, right? So we would be losing that. But again, I think there are real concerns and of including the California model. But if we're not following the California model, I do think we should also consider, does the ABA rule make sense, or should we just be starting from what is even simpler than that? Because the ABA, having both in California, rules of professional conduct that allow pure referral fees for attorneys and having the ABA model rule for paraprofessionals does make it very complicated. And what are we gaining by doing that, rather than just saying at this point, we are going to start with not allowing ownership of joint firms with paraprofessionals and lawyers and not allowing referral fees, and we will revisit that.
That's true, Amos. And I overlooked that. You're right. Another option is to not permit sharing of legal fees between paraprofessionals and lawyers, whether it's referral fee or not. You would still, I think, have to drop down to the issue of, can you allow referral fees between paraprofessionals, which I think you should. I think it would be hard to come up with a policy argument as to why not. And in that case, being a California exceptionalist, I would agree that was the approach taken by the working group, that the 1.5.1 standard should be the same for paraprofessionals as it is for lawyers. I think, again, the difficult issue is how and whether you're going to allow for fee sharing and referral fees between paraprofessionals and lawyers. I think that's the more difficult question.
One thing I'll mention, just to complicate matters more, because of course they need to be, is we have currently in our draft rule 1.16 A5 an obligation that paraprofessionals should know or reasonably know that the subject of representation is beyond the scope of their defined practice area for which they're licensed, and if so, they must not render legal assistance in this area and shall advise the client in writing to seek the services of a lawyer or paraprofessional authorized to provide legal services. So we have an ethical rule that's requiring them to at least tell them to go see a lawyer, or that it's beyond their scope. I would guess in practice, most of paraprofessionals will go beyond that and say, and I have a list of good lawyers that you should talk to. Otherwise, I don't know if they're going to be, doing very well in their business, because they certainly want to generate business through word of mouth as well. So, and I think what Elizabeth said is kind of underscores this as well, which is, I think most paraprofessionals, whether or not they're going to receive a pure referral fee or not, are going to be referring out clients when they need to. The question is whether or not they're going to hold on to matters that are still within their licensure, but where they're not feeling as comfortable. They're not quite sure that they've done that before, that this particular activity before, even though they're authorized to do it, and whether or not they'll just kind of white knuckle their way through it, or are they going to send that matter to another paraprofessional who they know this is their bread and butter work. They do it all the time. And one incentive would be if they were to receive a pure referral fee for that, or a lawyer.
Sorry, but they wouldn't be able to receive a referral fee unless that would be a pure referral, right?
Yeah, so that's the question, whether or not we would want to authorize that. But I hesitate to say that if we don't allow pure referral fees, that paraprofessionals are not going to be making these referrals anyway.
Right. I think that's exactly right.
We have an ethical obligation to send them out to somebody if their client is sitting there saying, I really need X, Y, and Z, and they know I can't do that. I need to tell you to go see a lawyer or another paraprofessional who can do that. That they're going to go, probably in 90% of the cases, go the extra step and provide them a list of names and numbers.
That's right. So can I try to not necessarily summarize, but I think one of the tasks we have is this about hour-long discussion on this is complicated, and we're going to need to explain this, both the background and the differences, the different options, and the policy reason for why we are suggesting one multiple times, right? We'll need to do that for ourselves again as we finalize a recommendation, and for the full working group. So I wonder what the best way to do that is. And frankly, I'm still stuck on the referral fee. issue between these three options. Because as I said, for reasons really, Greg, you just mentioned, I like the prior referral fee and the encouraging, sort of the California rule, which I thought was the same as the rationale for attorneys. I think Randy, you've convinced me that it's slightly different for paraprofessionals because of the, they're not able to practice in every area, but it's still the same incentives that I think we want to encourage. I agree that paraprofessionals are going to be doing that referrals anyway, even without the fee. But I think I'm still stuck on the ABA rule. And what are we gaining by doing the ABA rule as opposed to just not allowing referral fees? And I think where I want a little bit more information is on the division of labor, right? I think we do want, in your example, Randy, we do want to allow for a division of labor between paraprofessionals and attorneys. I think at the same firm, but certainly at other separate firms as well. And what does that look like if there's no referral fees allowed? How can that be accomplished to say, okay, the paraprofessional is going to handle X, Y, and Z, and the attorney is going to handle the rest if there's no referral fees?
If you take away referral and fee sharing completely, then you need to look at the ethics opinions in cases that go to analyzing when is a quote unquote fee shared, when is a fee split. And is it a percentage of what one person is getting? Is it a bargain for, conditioned on what is ultimately received from the client? Or is it something that is paid regardless of the outcome and not on perhaps even on a per client or case basis? And so if you take those authorities, the cases and ethics opinions on when is a fee split, when is a fee shared, in the context of a world where there's no fee sharing permitted at all in the rules, then really if you want what I was describing as maybe the access gains of this program where law firms and the paraprofessionals working together, you're looking at a situation where I think the paraprofessionals would have to be an employee of the law firm because otherwise you couldn't leverage their lower cost expertise to benefit your clients. They'd have to be salaried, because if they're salaried, then their definition of a fee split is never triggered. And so you could still have the combining together of a law firm with paraprofessionals, but absent any sort of fee splitting permission, I think they're largely left to be employees because they'd have to be paid in a way that doesn't trigger the test that creates a fee split. And if they're salaried, that's the safest way.
Or successive representation, right? Sorry, go ahead.
Oh, we have another attendee.
Or successive representation, right? So the idea would be, okay, you hire a paraprofessional first, and then you, again, refer out without a referral fee when it goes beyond. So again, assuming you don't get the same division of labor of working on the matter at the same time and splitting tasks, but you could potentially have a paraprofessional doing X, Y, and Z pre-litigation workup, but if it goes to litigation, it referred. Or again, the trick will be is there going to be a savings, right? Because you don't necessarily get a savings by hiring two different professionals for the same dispute. And that, again, that's part of my concern is, are people really going to be better off? Are you getting a savings?
Right.
You will in where the paraprofessional can handle the entire matter, potentially, but if it needs to be referred out and there's no division of labor and fee sharing or splitting, then likely in those cases where it needs to be referred out, that client's going to end up paying more and maybe substantially more.
I know we have Jason or a public commenter, just to jump on what Amos said, it just triggered a memory of Sarah Bove talking about how she approaches her work in Washington as a triple LT. I think the way successive representation is a good way to think about it, Amos, because I think her retention agreement is, I will provide these services up to this point. This is my fee. And at that, if we reach this point where you need to go to court and you need representation, then I can refer you out to a lawyer, and that becomes a separate matter, essentially, for purposes of these rules. She's engaging a lawyer on through a separate agreement. So she's not sharing fees with the lawyers. And the client understands that if we get to this point, I'm going to have to engage a lawyer at least for some number of hours in order to get this motion or this order that I need in order to complete the matter.
So I know we want to go to public comment, but I'll just say, and I hate to be all over the board, but I guess it shows I'm open-minded. I think I like that. I think that model works. Again, I'm concerned about the total fee in those successive representation, and that's why I think we need to work on the disclosures and work on maybe caps or some sort of regulation of that. But maybe the fees, maybe the sharing fees or split fee referral fees are not the best way to do that. And that might counsel towards, again, starting the most simple way, which is just not allowing referral fees.
Okay, Joshua, go ahead. Joshua?
I think you're muted, Joshua.
I'm mute. All right. Can you hear me now?
Yeah.
Does that work? Okay. Good morning. My name is Joshua Lee. I'm on the board of the California Association of Legal Document Assistants, same organization that Elizabeth is with. And regarding referral fees, I know there's been a lot of attorneys that are very nervous about paraprofessionals and the protecting the public and having good ethics, and just wanting to be completely on board with everything. But I'm of the opinion that referral fees would actually strengthen the public's safety with using paraprofessionals, because there are times where, even as a legal document assistant, there are times where I cannot, not even just the scope of what the client needs, but just, it's a matter that needs an attorney and not just a document preparer. And I feel that allowing for referral fees would strengthen the public's protection by people knowing what their limits are and having an attorney to refer them to, or if I can do X amount of work that needs to be done, and then in a limited scope, an attorney could fill in the other spots. I feel like it would be a good way to ensuring the public's protection. And thank you.
Thank you. Angela Grijalva.
Hi, this is Angela Grijalva. Thank you for allowing me to speak. So one of the things I think I want to emphasize and piggyback off of what Josh was saying, I think there is we want to incentivize the referrals and say, hey, when the paraprofessional puts down the boundary, says, I acknowledge I can't take this on. This is the incentive for me to hand it off, right? I did as much as I could. I did the intake, because there is still costs. I mean, when you think about it, I run my own business as an LDA. I still had to do cost intake, consultation, evaluation, talking to the client, listening to the issues, and then doing the handoff, right? Collecting documents, reviewing. There is still a cost. And, I think that referral fee will help cover those costs, because we have to remember, keep this a viable business model, right? So, and it would incentivize doing the good thing of handing the file off, right? And so that's that component. The other component where I heard discussed is, if we require the employment relationship, when we do that, there triggers all kinds of tax, employer obligations, relationships, which then wouldn't make a referral fee viable or for either party, right? Because you have to pay employer, employee compensation or withholdings and all that fun stuff, taxes and Then you have to have you know what I'm talking about. Well, I hope you know. Anyway, so I would just say that as far as when we think about requiring the employment relationship, let's think about all of those other things that it would trigger, responsibilities that would disincentivize the referral, right? And make it a burden, actually. So especially with AB5, right? Because we couldn't do the independent contractor relationship. Let's say that stands. The other thing I would say is, you know, currently I do, because of my experience, I do help clients up to trial. And then if it helps to understand, I do document packets, and depending on the number of assets and debts, whatever, and issues we have to address, I'll increase the price according to the amount of work. But I'll do document sets of, you know, your statement of issues and contentions, the memo to set, and then the file gets handed off to the attorney. And the client always knows at what point, well, that they are going to have to involve an attorney. And if you want me to help you get there, you need to consult with an attorney now, because I need to know what your strategy is, right? And I'm not going to give it to you. You need to figure that out. And so if that helps when thinking about where the handoff happens, how what other professionals are involved along the way, right? Because my clients will often talk to tax professionals, financial advisors, right? Beyond just attorneys, because there are other implications with tax ramifications and whatnot that happens in dissolutions. So there are oftentimes multiple professionals involved. And so, I don't know. Thank you so much.
Thanks, Angela.
And if I could just clarify one point in my thinking, is it correct that it would be a pure referral fee split? It would be a pure referral fee if, for example, a paraprofessional didn't do any work on a matter and referred it, or a paraprofessional did sort of everything they could up to a point and then handed it off, sort of the successive representation, but that other part of the work was not within the license. So either of those could not be done under the ABA rules, right? But it could be done under the California pure referral. Is that fair?
Well, in your second example, paraprofessional does what they can do commensurate with their licensure, and then they say, well, there's the court appearance that I can't do. I need to refer you to the lawyer. And the paraprofessional tells the lawyer, I want 10% of whatever you earn from this client that I'm referring for your in-court representation activities. That wouldn't likely be permitted under the model rule, because that paraprofessional isn't being co-counsel or doing any labor or assuming any responsibility. Like Greg says, they've withdrawn now, said, I've already done my part, I'm just sending you off. And I just want compensation for having made the referral. And that would be permitted in California as a quote unquote pure referral fee when you go through all the hoops and the client knows what's happening, but it wouldn't be allowed under the model rule. At least that's my analysis.
And I think that's confirming what I was asking. So that's helpful. And same thing with of course, the easier example, I think, is if the paraprofessional is not doing any work. So somebody comes to them, they say, that's not in my practice area, or it is in my practice area, but sorry, I'm busy. That would be a pure referral fee if they get some sort of referral fee, and would be allowed under the California rule, allowing pure referral fees if they comply with 1.5.1, but not under the ABA. Okay, so I think I'm clear on this. Again, it's complicated, so we're gonna have to encapsulate this, I think, where we can explain it in 5 or 10 minutes or less. And go through it. But I think where I'm leaning, and love to get Fariba in on this, is really not allowing pure referral fees and deciding between, does the ABA model make sense, or should we just start with no referral fees? And again, I do share the public comments about what the increased incentives referral fees would provide and increased income, and that's really where I start. So it is a difficult issue.
Yeah, and if the position is no referral fees, then we still have to decide what is the position on fee sharing, because pure referral fee is a form of fee sharing, right? So are we going to allow paraprofessionals to work together on one matter, essentially?
And also have to think about the persuasive reason why we're not permitting referral fees, because I think Greg raises a good point. I think we'll have a burden of showing anytime there's a change between the lawyer standard and what we're proposing as the paraprofessional standard. I'm not saying we can't come up with those reasons, but we should be able to say, reasons 1, 2, and 3 why we think it's a concern. And I'll just say before, I think we should leave this topic because I'm sure there are other things you want to get to. I think the concerns generally, as I hear the conversation of the last meeting, is like there might be an unintended consequence where licensed paraprofessionals are used as a non-certified lawyer referral service, or is otherwise gain in running in capping, even though I agree with Greg, when you closely read the statutes, that's not always a concern that comes to the fore, but there's a concern that someone could become a genuinely licensed paraprofessional and all they're doing is referring cases out. And there might be some sort of, I don't know, maybe potential harm, or for a variety of reasons, people are concerned that might be a result. That being said, the protocol set forth in 1.5.1 is client protective, and it would still exist. So I don't want that to be lost. I'm not saying that cures any decisions, because I do think it's a difficult decision, but clients are always going to be protected under that rule because it has to be disclosed. You can maybe even add something that says the person you're sharing the legal fee with is a licensed paraprofessional and not a lawyer, just to further disclose who the fee is being shared with. The terms have to be fair and reasonable. Amos, as you noted, it can't be increased certainly, but solely by reason of the referral. And the client has to consent. And only if you do those things may the fee be shared, even if it's a pure referral fee. And so there are still some protections if you retain the California approach. I just wanted to reiterate that.
Yeah, very helpful. And I again, that's what I started with, the position we should just track the attorney rules, and because they have that protection, they have that built-in protection, and there's some rationale for why California has allowed pure referral fees that I think do apply for increased incentives for paraprofessionals. So I think we'll have to, and I think Greg, your last point about we still need to talk about fee sharing also applies to between paraprofessionals, right? So if that's going to be different. So I don't know that we're all the way there, but I think this has been a very helpful discussion. And the question is, how can we move this forward, and what's going to be helpful for you, Greg?
Well, I think we need to loop in Fariba and get her perspective. And I think once you've reached some consensus on an approach, then I think we go back to the rules and try to craft them to reflect your policy position on this.
Right.
So I think we can move on to another topic. I feel, even though we spent the last hour and 25 minutes talking about this, I think it deserves at least an hour and 25 minutes, if not more, because this is one of the biggest issues, I think, along with firm ownership, that is the biggest policy issue underlying these rules of professional conduct for paraprofessionals. So I think it does deserve this level of conversation and thought. I do want to go, since we only have 35 minutes left, there are a couple other things from Leah's notes, from feedback we got from the full working group. I think there are issues that we can probably move through a bit more quickly, hopefully. And so would you guys, does that sound good if we just start from the top of the list? Because the first item is about Steve Fleshman's feedback on requiring them to bill out at 1/10 of an hour and incorporating that into the rules. And I didn't know what your response to that was, Amos.
Well, I mean, I think it's a good comment because I think it would be helpful and useful. But again, where I start from is I'd like fees to be reasonable, right? So I think we're delving in the weeds if we're talking about, how many minutes at a time can a paraprofessional bill? If I think we're skipping over the more important part, which is how much can a paraprofessional bill? Can it be excessive? Can it be unreasonable. So I would love to see us do some regulation in this area, but I think we're stuck at sort of square one, and I don't know how we would be able to regulate what increments paraprofessionals need to use, but we can't. Yeah. We can't regulate how much they can charge, and if it has to be reasonable.
My concern with this obviously is that it assumes that they all will be billing out, or at least a good percentage of them will be billing out on a time basis, which may or may not be true. We want to encourage flat fees as well for a lot of the activities. Also, I'm not sure, and I'll kind of rely on Andy and Randy for this, but is there another jurisdiction that has incorporated this type of requirement in the rules of professional conduct? I'm not familiar with any rule for lawyers in any jurisdiction that requires as a disciplinary standard that they must bill out at 1/10 of an hour.
I'm not aware of anything in rules of professional conduct to do that.
I'm not either. We'd have to take a look. I'll just make a quick comment. If we think about resources of the regulator and this being a rule of discipline, I just worry thinking a client that got a bill that was detailed at 1/4 of an hour, not 1/6 of an hour, and sent in a complaint that could take up, some investigatory and prosecutorial resources, which frankly, could be detrimental to the organization. I think that there are ways to address this. I think it is important, and also, I want to note this issue is generally addressed in statute, not as a rule of professional conduct with the consequences being discipline. And 6148 just simply says bills for the fee portion of the bill shall include the amount, rate, basis of calculation, and other method of determination for the attorney's fees and costs. And I think the market could bear how to do that. So I don't want to spend too much time on this, but that just, as Amos says, is getting in the weeds. It's kind of micromanaging. Innovation might come up to make things more efficient in other ways. It just does not seem like a provision that's appropriate as a rule of discipline, in my view.
And what would be the rationale for imposing it on paraprofessionals but not lawyers?
Mm-hmm.
So I do agree with these comments as far as disciplinary rules for rules of professional conduct, but I do think this could be done in the rules of court. And I think that might be the same answer for any kind of regulation of fees. To the extent the concern is we don't want to tie up resources in dealing with fee issues, there still can be a bright line rule, including various requirements, whether it's the billing in 1/10 of an hour or tracking 6148 or having some sort of fee caps. Just because they don't belong in the rules of professional conduct for discipline doesn't mean that we shouldn't be looking at it as a working group or a regulation subcommittee, and maybe there's a rule of court or other solution or legislation to this.
Just to follow up on that, we have incorporated 6148, the provision that Andrew just cited, in Rule 1.5.2 in the written agreement. So we're tracking that language, that statutory language in the rules now as a requirement that the paraprofessional, any basis for compensation has to be included, including the hourly rate, statutory fees, or flat fees, or other standard rates, fees, or charges applicable to the matter. So as a broad disciplinary standard, if they don't include that in their written agreement, they could be subject to discipline if we were to adopt this rule.
So maybe we can look at, because I do think two of the issues that we're going to need to look closely at are the written agreement rule and the informed consent rule. And maybe we do take a look at the details in there and see if we should be tweaking them from the 6148 language to something that might be appropriate for paraprofessionals. Again, I think for me, it's a disclosure issue, right? It's making sure consumers and clients get the information. And I think that was Steve's point as well.
Okay. I do have some questions, and it is next on the list, Rule 1.4.2, which is the informed consent. Let's see. So the first bullet point says, does informed consent need to be included as it is addressed elsewhere in the rules? I'm not sure what that means.
So this was raised, I think, Andrew, you may have raised this. Somebody raised it basically saying, informed consent is addressed elsewhere in the rules. Do we need to have a separate provision for?
Yeah, that was my comment. And I don't think I'm looking at, I'm trying to find Leah's comment. I'm not sure I'm looking at the right version, but I think Steve Fleischman raised a concern about informed consent generally with this rule. I might be misremembering who raised the comment, because the precatory language in A, I think, has reference to informed consent. Mm-hmm. And then I thought it was subpart 3, but I might be wrong. It talks about, the risks agreeing to obtaining the legal services from the licensed professional. And so my comment was, risks are defined as part of what constitutes informed written consent, which is required under A. And so I just thought subpart 3 was redundant. Unless you want to specifically identify, and then there's also a question of, is this over regulation or micromanaging? Unless you wanted 3 to specifically say, here are the risks of representing me as a licensed paraprofessional as opposed to a lawyer, which might result in discouragement of a client retaining the licensed paraprofessional. That's a policy issue to talk about. But what I was trying to raise was in the precatory language of A, it talks about getting the client's informed written consent, and informed written consent is defined under 1.0.1 of the rules of professional conduct. And it includes communicating and explaining the relevant circumstances and the material risks, including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. So I thought 3 was subsumed into A.
That's a good point. And I think it came up also in the context, we were talking about whether or not the paraprofessional board or the state bar would provide a form that the paraprofessional would have to give to the client and obtain their informed written consent, have them read the form, understand the disclosures, and sign off and say, yes, I want to continue to potentially pursue this relationship. And I think the point was made, and I thought it was a good one, is that based on the definition of informed written consent under our rules, it implies that the facts and circumstances matter, right? So what needs to be disclosed depends on the facts and circumstances that is presented by the client and the matter that they're asking you to take on. So that means it can and will change. And so it would, if we're really saying informed written consent, that is not, because it is a defined term, we're asking the paraprofessional to do some level of assessment and understand what needs to be disclosed and what the risks are based on what the client has told me about what they need and what their circumstances are, which can be probably a heavy lift, especially, and this is a point that I've made before and it's still sticking in my head. What is the triggering event that requires the paraprofessional to obtain this writing? My understanding up until this point has been first meeting. If somebody comes to you and says, I'm interested in learning more about your services, is this the point where you need to make these disclosures? Okay, before we begin, you need to know, I am not a lawyer. These are the things I can handle, and these are the things I can't handle. Part of the risks are if your matter becomes more complicated and your legal needs exceed my licensure, I will probably have to refer you out to another lawyer. A list of things that are always going to be common every time you have a new intake with a potential client. And if that's what we're talking about, a form that's developed, then we're not really talking about informed written consent within the meaning of the definition. Does that make sense?
Yeah.
We're talking about mandatory disclosures, essentially. And so if that's the case, I think one approach to simplify this whole process is to, again, go back to this idea of what is the triggering event here? When do they have to obtain this? And what are they providing to them? And if what they're providing to them is the same in every instance, or at least, the same for every family law paraprofessional as opposed to collateral criminal paraprofessional, then it should be probably a form that's developed by the state bar or the paraprofessional board and provided. And it's similar to, I think Randy had alluded to this before, the notice that a lawyer must give to a client or former client if they're going to initiate an action for unpaid fees, or that they have a right to demand mandatory fee arbitration and what your rights are and certain disclosures of information, how they can go about that process. It's the same every time we provide them a form. Unless they get a signature, unless they provide that form, they can't proceed with the action. So it may be something that, rather than trying to broadly say, hey, you need to disclose all the risks to this client, we can say, these are the risks that we've identified. And these are the potential benefits. You need to know I'm not a lawyer. You need to know these are the things I can do. These are the things I can't do under my licensure. And I need to obtain your signature before we can really even go any further in this conversation. And then take that signature and put it in your file. Because if later they say, hey, they never told me they weren't a lawyer, then then we have the document, obviously, from an evidentiary standpoint to determine whether or not they violated this rule.
So from my perspective, this is a very helpful discussion, and it was helpful in the full working group too. I feel very strongly, and I know we've talked about it before, Greg, and I think maybe it has not been among this full group, but what I mean and what Fariba and I put together is intentionally and clearly an informed consent requirement. And that does follow the definition of, whatever it is, 1.0.1e. So the intention here is specifically to not be a mandatory disclosure requirement. There is a separate written agreement with mandatory disclosures, and this is intended to be informed consent as defined in informed consent, and not only the risks, but also alternatives. So the idea would be, if there is a low cost or free attorney available, they're also going to need to disclose that. And we had long discussions about this, and where we ended up was the agreement or consensus that it would be nice to require it to be in writing. So, and that is not a new concept. There are other written informed consent requirements throughout the rules. Changing it from a written informed consent requirement to just a written disclosure that there is this form in the file would not satisfy me, and that was not sort of the intent. But we also discussed it might be very helpful and extremely useful if we did come up with some sort of forms of what the standard, in every case, the common disclosures, if you will, that could be filled out. But I agree that probably just a form that's signed is not sufficient because there's going to be different circumstances. So I think what my recommendation would be is if we try to put together some sort of standardized form that has blanks, or that has instructions on this is required but not sufficient to meet your informed consent, because I think we don't want to make it difficult. I think we do want to try to standardize some of the disclosures, and I think for me at least, I'd be interested in your feedback. I think it does make sense to have some mandatory disclosures in connection with an informed consent requirement. But I don't think we want to, or I strongly don't want to move away from an informed written consent requirement. And if you think we can't use forms, I understand that, but I think we should be able to have a written informed consent requirement and put together some helpful samples or optional or mandatory forms with blanks that we could really try to help the paraprofessional make sure they are disclosing the things that at least some of the things that they for sure need to disclose.
Amos, what is the difference in your mind between the mandatory disclosure and the informed consent? I think the confusion is, what are you getting consent about if other than the things that need to be disclosed? I guess I'm struggling with and I think the working group was struggling with what is the distinction? So when you say you very strongly feel like they need to be two different things, what's going to be in one document versus the other?
So I think that's the fundamental distinction, is they're not documents. An informed consent requirement can be confirmed in a document to show that it was done. I think that's fine. But informed consent means that the client or prospective client needs to be informed of several different things, the circumstances, to make sure they have all the information they need to make an informed decision. And that's different than, I think what Greg was just explaining, that's different than just having a document in the file that shows you said these certain things. I don't think, in my opinion, I think we can get them very close, right? I think we can have a standardized form that has a lot of the common disclosures, like I'm not an attorney, this is the rate, this is what I'm allowed to do, this is what I'm not allowed to do. But there may be other things that are not, like what the alternatives are. You could get a free attorney that's available, or there's an attorney down the street that charges less than me. That would be a relevant fact that I think would need to be disclosed in order to, your case, includes things beyond my license. So I can only help you with this aspect, but not your full case. We may be able to do forms for a lot of it, but I agree, just a form that's signed in the file isn't necessarily mean there's informed consent.
I kind of come back to Lee's question, because I'm still struggling with what are they consenting to? Consenting to continuing the conversation with what exactly are we asking the prospective client, because they're not a client yet, to consent to, just to proceed with the conversation? And because the reason I ask, I'm thinking of this obviously from a regulator standpoint and how we actually enforce a rule like this. In order for the paraprofessional to really do a full assessment of what the alternatives are, they're going to have a pretty detailed and intimate conversation with the person about their finances. There's a lot of information about their situation, about the matter. So now we're getting into confidential information. So there's duties to prospective clients under our rules for confidential information. They're taking on confidential information. And then they're going to have to go away and draft this thing, because they're going to have to craft it each and every time specifically for this one person. They're going to have to call up legal aid and say, I have a prospective client, here's their situation. Can you provide them free legal assistance? I'm sure the answer will be maybe. So that my only concern, I agree, I would love for prospective clients to have all this information and understand what they're getting into. But from a practicality standpoint, I don't know if we can really identify all the alternative choices, all the specific risks in general at this stage for the client, and obtain their consent. And again, to consent to what? To representation, or to consent to consider representation. This is why I'm really hung up on this whole, when is this obligation triggered? Because that's a very important thing from an enforcement standpoint. And what is the paraprofessional what information is the paraprofessional going to have to obtain in order to provide this form of informed consent? And are they going to be capable of doing it thoroughly enough to comply with the rule?
Right. So I think this is a very helpful discussion, because I think we've done this a couple times.
Yeah.
And my feeling about this is we keep getting pulled to not have a separate written requirement, or not have a separate rule, or combine this with written disclosures, or the the other rule. And I think we've come a long way in making it clear these are two different things, making it clear we're talking about informed consent, separating it in the rules from the written requirement. And I'm not feeling the tension that you're feeling, but I think we should discuss it because I think it's important we address it. But I think this is consent to representation. And at least a draft rule, I believe, that we put together, I think it's in your draft as well, is that it's prior to providing legal advice or representation. So I agree, the earlier the better, but I agree that in all cases, or maybe even in most cases, it's not going to be able to be done on the first conversation. If it's a phone call, can you help me? But prior to representation, prior to providing any legal services, the client needs to, provide informed consent. And I don't see why that's complicated or why that's inconsistent.
Well, the reason I'm confused is when you say consent to representation, that immediately makes me think written agreement. And so the two are now suddenly subsumed in my mind as to why are we, what's the purpose of this document as opposed to this document? Because we have mandatory disclosures in the written agreement part, some of which overlap with what we have here in this rule. And so I'm confused as to why they're two separate writings. Number one, there may be very good reasons to have two separate writings. One is there are certain things we really need to highlight right off the bat. And if they are separate writings and they're really important disclosures, I almost think they should be one page. So, and in very simple language so that people understand before we get into the contractual language that can be a little bit more confusing for a layperson, and make sure those disclosures are there. But the minute we start talking about crafting and customizing the risks and based on the facts and circumstances of a particular client, it gets more complicated, I think. And so I think we need to, I'm just, that's my level of confusion. If we're consenting to representation, that to me says it's a written retention agreement.
Yeah, so, and this again is where I think we started. So I think we've had this conversation several times. And I think my basic response is this is an informed consent requirement. It's different than a written disclosure requirement. And that's, in my mind, the fundamental distinction that changes it, that I think you and everybody else on this call understands the difference between a written disclosure and an informed consent requirement. Now, I think we have come on so they come from a different place, they're different requirements, they're going to be different rules. The timing on them might be the same in some cases. I agree that practically speaking, in at least some cases, if not most cases, you might be, a paraprofessional might be sitting down at the table after some preliminary discussions and doing them both at the same time. But I think that doesn't mean that they're the same thing. An informed consent requirement is different than a written agreement requirement. So I started from the place where I didn't think informed consent needed to be a written requirement. I'm fine if we decide that informed consent is just a separate thing altogether and it's not part of the written, there's no separate writing for it, but there is an informed consent requirement. But I think in prior discussions and with the full working group, I think there was feeling that there are benefits to having that informed consent in writing as well as a separate writing than the written agreement.
I think for me, some of the struggle is, and Greg articulated it well, informed written consent necessitates the unique facts and circumstances of any given case. And you look at the rule as proposed, and these are mandatory disclosures regardless of the unique facts and circumstances that have to be given in every written case. And so for me, I'm just struggling with, and I am inspired and I want to understand better, Amos, where you're coming from, but how you're harmonizing the mandatory disclosures with informed written consent when one is going to be required in every single case, no matter what the unique facts and circumstances are of the client's needs, and the other is not. And you can't dictate what those disclosures are going to be because you haven't had the conversation and the client's And client's matter might change. Informed written consent might be effectuated multiple times throughout a representation.
What do you mean informed written consent wouldn't be required in every, or whether it's written or not? What do you mean it wouldn't be required in every case? It's only required when? When you're saying that, Andrew, what do you mean?
I'm not sure what comment I made. So certain rules require informed written consent, and informed written consent is going to be different in every circumstance. I mean, there might be some canned language generally, you know, if you do employment matters and certain issues keep coming up, but informed written consent is necessarily going to be different. If you look at the rule, if you look at the definition of it, it's the relevant facts and reasonably foreseeable adverse consequences. That's going to be different depending on the case and liabilities and risks and claims that might be available. I mean, so to pre-necessitate what the disclosure is going to be, and I might be coming from this in the wrong place. It's just, that's what I'm struggling with in my mind.
So again, I think it's very helpful. What I would suggest we do is, rather than start with the language that we drafted before that's causing all this confusion, is start with a very clean, pure, informed consent requirement. And then get into the discussion, which again, I think this is where I started already, and so I've been through this, but I think we should all do this together. We are proposing that there be an informed consent requirement, which is separate from the written agreement requirement that includes mandatory disclosures. So let's work on this. We don't have to start with the language that is drafted if that's causing some confusion. Let's just draft the best we can an informed consent requirement. And what Fariba and I did already is we said, yeah, but there are some common disclosures that would make sense in the context of getting informed consent of a paraprofessional, because it's a limited license. And so it might be practice area specific, but for family law paraprofessionals, probably the informed consent, to get informed consent, there are going to be certain disclosures that are required. And why can't we standardize that in some way or create a form to help? But if creating a form to help means it doesn't make sense to require informed consent, I think we're undermining the purpose of requiring informed consent. So I would be much more comfortable with a clean informed consent requirement. I think Fariba would be more comfortable with as much as we can get into a standardized form. And then we got to sort of combine, I think we can combine those concepts, because whether it's, some, canned or standardized language, or some disclosures that might overlap or be similar to what's in the written agreement, I think in order to get informed consent for a licensed paraprofessional, there are going to be certain things that are obviously things that should be included in the discussion. And so I don't think having a standardized form that has some, has part of the required discussion undermines an informed consent requirement in any way. But if that's causing confusion or concern, let's get rid of that.
Well, no, I think I think because we're the rule nerds, and we really know, like, the informed written consent is such a well, it's a defined term. And I think lawyers beyond the legal ethics world may have a different sense of what that is. Obviously, every informed consent includes disclosures. Some of them may be mandatory disclosures and pre-can. That's fine. What we're getting hung up on is the relevant facts and circumstances, the unique circumstances, and what the obligations it imposes upon the paraprofessional in order to discharge that duty. And so what we could do in that rule is to essentially say, these are the mandatory disclosures that are the same in every single case. They need to be included in this mandatory disclosures and informed written consent document. And then also, you must disclose any relevant risks of proceeding with representation, as well as any potentially available alternatives. My concern with the available alternatives is that I'm not sure we want to put paraprofessionals in a position to becoming navigators towards legal services, because I'm not sure they're going to have that level of expertise. Really, I think that they could probably, you know, say these are legal aid services services that may be available in the area that could provide. But we know just from the process of for people to obtain legal aid, it can be complicated. It can be very fact specific, and I wouldn't want to suddenly put paraprofessionals in a position because they're to be disciplined because they didn't understand the entry requirements for a particular legal aid program.
Yeah, very good points. And I agree. But that's a very different concern than objection to having an informed consent requirement at all and just switching this to a written disclosures, right? So the issue is, yeah, what level, the idea is it's a consumer protection issue, right? It's a making sure that the prospective client has the information that they need to make an informed choice. And yeah, we need to work through what that is. Certainly alternatives being available, having a low cost attorney or a free attorney available certainly is a relevant fact that any person in that position would want to know and would be relevant to the decision. So how can we standardize this? How can we make it easy? Yeah. We don't want to make it hard. We don't want to make it advertising for attorneys. We don't want to necessarily dissuade people from using paraprofessionals. I agree with all that. But we do want the prospective clients to be informed enough to make an informed, reasoned decision. Absolutely. It's a defined term. It's not a new concept.
Absolutely. And from a consumer protection standpoint, I feel that some of this information needs to be provided to the prospective client right away. That's why that's the reason we were focused on what are they consenting to. If they're consenting to representation, like it's a legally binding document that says you've now consented to representation, that concerns me, because I don't think that, one, the problem with the informed consent as it's defined is it requires the gathering of a lot of relevant information, potentially confidential information. It takes a while to actually craft an informed consent that's informed by that information. And the client may be a week into the conversation with the paraprofessional before they're getting some of these mandatory disclosures. From a consumer protection standpoint, I think there's some mandatory disclosures that probably should be given to the prospective client as soon as they walk in the office, before they even begin eliciting confidential information from the prospective client, that they know, hey, before we begin, you need to know, I'm not a lawyer. There are alternatives for you out there, and here's a list of them. It's just that type of thing, because that seems to be protected, because it's a lot easier, I would think, for a prospective client to say, whoa, I didn't realize all this. Well, maybe I'll go see legal aid, or provide, before they go further down the road and they invest in this relationship and feel like now I'm consenting to representation.
So I want to be conscious of the time, but I do want to say one thing. I was going to ask Amos for you to, because I think you have a better understanding of what's in your mind than any of us, to draft what you think would be an informed consent versus mandatory disclosure, whether the informed consent is delivered orally or not. But then I'm looking back to what you drafted, right? It was attached to one of our agenda items. And your informed consent is not Greg's informed consent. It's not the informed consent in the rule. It's not case, fact, pattern specific. The items in this draft informed consent document are, you've got informed consent, and then we have written agreement and mandatory disclosures. This is the March, just an attachment, I think the March 16th agenda item. Here's what's informed consent. They're not a lawyer. Reasonable disclosure of available choices. The risks of agreeing to a paraprofessional. The potential need to hire a lawyer. The existence of any financial arrangement such as referral fees or fee sharing, and a reasonable estimate of the total cost of services. I guess only F is actually related to the specifics of the case at hand. So I think that all of the items in the draft that you prepared, in my mind, they're disclosures, and they're actually duplicated in the disclosure section. And that's really different from this other informed consent we're talking about, which is like you get to understand what's going on in the case, the risks associated with a certain strategy. Those are not what's in your draft informed consent.
No, they're not, Leah, but again, informed consent is already defined to include that specific information. So the minute you use the term informed consent in our rules, you have to refer back to that definition, which incorporates all of the relevant facts and unique facts and circumstances.
So that's why there's the hang up, because I don't think that's what Amos was initially contemplating.
So right. I think that's the hang up for the exact opposite reason. I think I clearly and expressly intended informed consent. I think the confusion is by including some disclosure language of these are the types of things that need to disclose, we've circled back to say, well, we're already including that in the written agreement. Why should we have two different writings? And that's where I want to just pull ourselves out of that confusion, because it is not intended as a disclosure or disclose these facts 3 times. That's not what's intended. What's intended is an informed consent requirement. And the informed consent requirement clearly should include things like the things listed both in my initial draft, Greg, and your updated draft, and things like, risks and alternatives, just because that's what it means to be informed consent. You can't have informed consent without that disclosures, but those disclosures are not enough to have informed consent.
And what was in your initial draft does appear in 1.4.2. It's A1 through 6.
That's what I thought. And it's really risks and alternatives
right.
and fees, and I'm not an attorney, right? So sort of the basics of these things clearly need to be included in any kind of informed consent discussion.
And we can get, maybe I could talk to Randy and Andrew about this. It may be that we have to have something in the comments to this rule that say, as long as this information is provided, it meets the requirements of informed consent pursuant to Rule 1.0.1, because it wouldn't, just as if it's really these disclosures that we're talking about.
Okay, but just to be clear, that's the opposite of what I'm trying to clarify, right? I'm trying to clarify that this is not sufficient. Yeah. Disclosures, this is not a written disclosure requobject.
Well, this is where we keep chasing ourselves. Disclosure is subsumed in informed consent. Exactly. You have to disclose something before you can obtain consent. So you have, anytime you're getting informed consent, you have to make disclosures.
And I'm trying to understand what else you want besides the disclosure. That's why I keep coming back to, I think you're going to have to draft something, Amos, because I don't get it. I don't get what else you would be consenting to that's not in the disclosures, unless it's this other stuff that's like case specific, the strategy, the other things. And then you get into that bifurcated, the timeline approach. I'm not getting what else you're consenting to besides what's being disclosed to you.
Right. So that's the confusion. So I think we all should work together on figuring out how to make this a meaningful informed consent requirement, and to see if we can come up with some forms or some language to include what would be the common things that need to be disclosed, and not accidentally combine this with the separate written agreement requirement, which really comes from a totally different place and is a separate requirement. So I think I could try to come up with some canned language that should be disclosed in every case, maybe specific to the different practice areas. But again, I don't mean just having that form is enough. That would just be the start of this would always be required disclosures in connection with getting informed consent.
But how is disclosing it and getting the client to consent? And I'm really hung up on under 1.4.2, I think it's 1 and 4. So that's not going to change. Those are pre-stated statements that the client must know about. How is it different in your mind, whether that's effectuated under 1.4.2 or under 1.5.2? Which is the written agreement that has to be included in the agreement, and the client has to sign that written agreement. So why couldn't, I think some of these things could be split out. 1 and 4 in my mind is what I'm stuck on. And then for me, and I fully concede I might be being a monkey, throwing a wrench in the engine here, because I'm an ethics nerd, but informed consent is intentionally non-prescriptive because it's going to change in every circumstance. And there's a need for that. And there's case law for that. And there are ethics opinions about that. And that's an important concept to carry forward in this paraprofessional group. And so as I'm hearing this conversation, I think all the concerns you are searching for and worried about, Amos, can absolutely be addressed. I just think we need to be careful and precise in the language we use and how we want to effectuate the duties and obligations.
So I would love your help. What I recommend is that we try to revise the language to be clearly an informed consent requirement consistent with 1.0.1e. And we also try to not just have a generalized standard out there, you need to get written consent, but help paraprofessionals with a sample or a form or examples, because that's really what we're talking about. I think there's some confusion about, what, like Greg mentioned, in talking about alternatives, what would the alternatives be? In discussing the risks, what would the risks be? That's all pretty amorphous, and we're probably in a position where we can think through some of those issues, and whether it's in comments, whether it's in a draft sample, whether it's in the rule, we could do better than just say, a simple, you need to get informed written consent. So that's, I think, with a struggle, because I think I tried to do that and I've caused confusions, because now it looks more like a written disclosure requirement. And I'd like to go back. This is an informed consent requirement, and I'd like to put more meat on the bones, whether that's in comments or sample forms or other things that we can try to help paraprofessionals meet their ethical obligation of getting informed written consent.
And I would just say, I know we need to get off, but I would say I disagree. I do think it reads like an informed consent. It uses the term informed consent with its asterisk, which indicates that you're asking them to obtain informed consent, which has a meaning, that you're requiring certain disclosures as part of that informed consent, and then other disclosures that are going to be really changing client to client. My deeper concern is, one, it's going to be coming too late in the process, and two, I'm not sure paraprofessionals are going to be in the best position, if we want try to make it earlier in the process, the best position to make the disclosures that we want them to make, if that's what we're looking for. So I think we probably need to end, but I think we need to do a little bit more thinking about this, because I think it's critically important. I think there has to be some form of consumer protection here early in the process. So we're all on the same page with that. We're just trying to come together in terms of understanding how can it best be executed, because we're just struggling right now with the rule as it exists right now, that it's just, one, difficult to enforce, two, it's difficult for a paraprofessional to discharge this obligation when we want them to. So, but we'll work through this. Okay, if we could just spend 1 minute. So we learned from Fariba that she's got this great opportunity on the 13th. She's not going to be free until 12:30. I don't think we want to have another meeting without Fariba that we can avoid, but yeah. starting the meeting anytime after 12, it's end time, will require us to kind of scrap it and move on to a new date, giving 10 days notice. So our choices are to start the meeting slightly before noon, which we can do technically according to OGC, and then have it go for 2 hours, and Fariba could join us at 12:30, or just pick a new date. And I'm kind of thinking at this point, if we could get availability of Amos and Fariba later today or tomorrow, maybe we just pick a new date so she can be available for the whole time. But I don't know, Amos, anybody thoughts on that? I just want to resolve that issue. My schedule is wide open on that Thursday.
So is mine. So
we can't do it that Thursday. See, if we want to keep it that Thursday, we have to start it before noon. We have to start it within the original time frame for the meeting. She's not available till 12:30. So we could start at like 11:45.
Yeah.
We could schedule it for like 2.5 hours, 3 hours. Should we just do that?
Sure.
Yeah,
okay.
I think so, because we already have our scheduled meeting on the 20th, right?
Yeah, I think we have them once a week. Okay, then I'll work to get that done.
Okay.
Okay, thanks everyone.
Thank you.
Thank you.